Hi everyone, as promised, we are going to discuss a technique to read judgments faster and save 70% time. आप इस टेक्निक को यूज करके 70% टाइम बचा सकते हैं अपना. So we are going to use this technique called OPRA and I'm going to apply it to a case called Vinay Sharma's judgment. It was the Delhi gang rape case. Okay, and we are going to see how to find out the findings of the case. Now, what does OPRA stand for? For any judgment, we are going to have four parts. Opinion, which is the opinion of the judges. P for precedent, meaning all the case laws that are mentioned in the judgment. We are calling them precedent. Then the third is going to be the argument of one side. So, respondent's argument and appellant's argument. So, R stands for respondent's argument and A stands for appellant's argument. Now I'm going to open the case and I'm going to help you in finding these specific points. Okay, and we're going to do a screen share. So we'll do this with Vinay Sharma's judgment. So let's get started. Here is the reported judgment from the Supreme Court's website on Vinay Sharma versus Union of India and others. First, I will help you identify a few basic things and then we will directly apply the OPRA technique to find the answers. So here we see it written in the Supreme Court of India, criminal appellate jurisdiction. Very important to know the jurisdiction of the case before the Supreme Court. Then we look here, the judge passing the judgment is Justice R. Bhanumati. Then we go to the bottom of the case and we see who are the judges who have signed it. So you see that Justice R. Bhanumati has written the judgment for 3 judges, right? So it was a 3-judge bench. Now, when you write answers like this, let's say in the judiciary exam, it's going to be very much appreciated by the examiner because you're adding more information very fast. Now, let's say you want to understand the facts, right? Let's see, it's written here. The writ petition is filed under Article 32 of the Constitution by the petitioner who is a death row convict, and it is written very clearly. The petitioner has challenged the writ petition, challenging the rejection of his mercy petition by the President of India. So, under the Constitution, there's a possibility of getting mercy from the president, and this mercy petition was rejected and he has filed a writ against that. There are grounds mentioned for why this writ petition should be maintainable over here, right? And now if you want to look at more details of the fact, you can, but it's not needed because until here we are going to be more or less on very brief facts and the point of law, right? Now we go further and see what is there in the case. Right now, most people read the case cover to cover, which is a big problem. So how you go about this is you go to the bottom and you see how the petition was answered. So it's written in the result, we do not find any ground for an exercise of judicial review of the order of the President of India rejecting the petitioner's mercy petition, and this writ petition is liable to be dismissed. So you're very clear now that the Supreme Court rejected the writ petition against the President's decision. Now you got the answer really fast. Now what you need to do, instead of reading the whole judgment, you want to identify and mark out the paragraphs so that you can first find what are the relevant paragraphs to read. You don't have to read the whole judgment. How do you do that? Every part of the judgment is going to have only 4 parts. So let's take an example. So we'll see the first sentence at the beginning of every paragraph. Now paragraph 3 also is on the facts, right? So we're going to scroll below and here it's written contentions, which is great. What is contentions? It is either respondents or appellants' arguments. Now you can see here, you can mark it also. Dr. A.P. Singh, learned counsel appearing on behalf of petitioner, challenged the petition, right? And now every line, it was submitted that the relevant materials were not furnished. Now you just mark it. It is the counsel for petitioner or appellant. So we'll mark it as A, OPRA ka A, okay, appellant's argument. Then I will scroll below, argument of the learned counsel for the petitioner. Again, it's A. And I am not going to use these things unless I have to flesh out something very advanced in a High Court or a Supreme Court to differentiate this. For the purpose of most exams where I just have to remember what was the ratio of the case, then I'm not going to look at the argument specifically in a lot of detail. So I go here. Again, all these are petitioner's arguments, right? Appellant's arguments from an opera perspective. So it is A. I will mark this as A. So I could even write, if my tool allows, I could write as A. I've written A like this. And I'm not going to read this. I am only going to read the opinion part of the court. And from that, save what's important. Now see, countering the above arguments, Tushar Mehta, the learned Solicitor General, submitted. So now again, I am not going to read the rest. I understood this is the respondent's argument. So this is R. So I'm going to take my tool and write R over here. And I can actually increase the font size. This is Foxit free PDF reader. So you can use this. Like I can mark it like this. So I'm not going to use this. Petitioner challenges so and so. Now here you can see what is happening here. As per article so and so of the constitution, president has the power. So now court is opining something, the grounds for judicial review of. So now I am going to write O and P here, right? Opinion. Here is opinion. And these are the precedents that are being cited. So actually this is not the opinion. This is the precedent, because it is just recounting. Court is recounting what is happening, right? Same here, same in the above paragraph. They are not giving opinion right now. They are just sharing what is the constitutional provision, what are the other case laws, right? We scroll below. Again here, what is the court doing? Precedent. I may not use or memorize all the precedents until we shortlist which are the 3-4 top cases to remember, to form a chain of cases so that I can show that on this point, this is the master case, this is the subsequent case. So I'm going to move on. Again, what is this? In Shatrughan Chauhan, the Supreme Court discussed. So this is precedent. And I scroll below, and here you can see, let us consider a present writ petition and grounds urged by the petitioner. Again, they are summarizing this. Again, they are summarizing here. Court is summarizing the arguments. Now we will see. See, we are of the opinion, insofar as the contention by the learned counsel said this, we are of the opinion that such a course would not be appropriate. Very good. I'll just write O here. By the way, this is a free PDF tool. You can use it too. Now, I will go ahead and see below. If there's any new law laid down also, I will check. I will read like this. I will mark it. Now again, learned counsel of the petitioner submitted so and so. Again, now this is saying regarding the contention of the governor, of the lieutenant governor, which means now they are specifically going into every contention and giving their opinion. So I will see in the beginning if they have answered it somewhere. So here, we do not find any merit in the contention that there was non-application of might on the part of the minister. So these are the specific findings of the court which I want to see. This is not the law. This is what the court decided in that matter. I will scroll further. Now here we see non-placing relevant materials before the President of India, and they were out of consideration. I can see here they are relying on a particular case. So I realize that this was a P, right? Shatrughan Chauhan is the P part. It's a precedent. Now they are relying on it. So I should refer to this because here the opinion of the court relies on it. So I will keep this in mind and I will refer and I will add Shatrughan Chauhan in the list of cases I want to remember for mercy petition related cases. Let me see what's the answer. We will check here. This is also to satisfy ourselves. We've asked this. So this is the opinion part of the court where they are saying they are going to give their decision on this, right? I'll scroll below. Right? They're recounting again. This is the O. But the last, we find no merit in the contention. So we know what is the decision here based on this. Correct? I know now that they disagreed with the fact that relevant materials were not placed. Do I have to read this? No, I want to only find the position of law. I'll come to how to find that. Non-placing of relevant materials, again, these are all the O paragraphs, by the way. Huh? So I'll mark these, and later when I'm going to fish for the right points, I'm going to come back to this and find the 2 or 3 important points. See, again, here they are citing the precedent of Shatrughan Chauhan. Now, this I will read, okay? Shatrughan Chauhan, they have said this. One relating to, so what are the reasons for review of the mercy petition by the court? So it says that there should be reasons, firstly. So it says that whether there should be reasons communicated and whether materials were placed for consideration. Now I know. So they are citing Shatrughan Chauhan, in which a Puru Sudhakar case was cited. Correct? And then I scroll further. And again here I see this is the opinion part where they are deciding that these materials were given or not. Now here's the answer. There is no merit in the contention that the medical report was not placed. So this is all factual and I'm not going to memorize it. I see one more interesting P here, which says that as per this case, exercise of power of review of mercy petition is only subject to challenge indicated in the article, in the grounds mentioned. And it cannot be contended that the highest constitutional authority had not applied it. Then we scroll below. This is again an argument, right? Learned counsel for the petitioner urged. Now let's see what the court decided. Here, there is no merit in the contention that the investigation report was not placed and the relevant materials are out. So every point is being outlined here and I'll do O. And basically, now when I'm reading it, what do I realize? I realize that primarily this case is a factual case because we don't see any new law being laid down over here on the principles. This case has relied on the findings are primarily factual. It is not laying down new positions of law. And in fact, it is following positions of law laid down in earlier cases. So when I'm going to learn cases for Article 72 or 161 of the Constitution, I'm going to focus on the past cases also that were there, the landmark cases that we saw, Shatrughan Chauhan, and we will add this case of Vinay Sharma as a byline or an additional case that this was a recent case where the position of law as in earlier cases was upheld. And that's done. Now you can read the court's opinion on further issues, but this is what you will find. Now the next thing is that once you've read this judgment, how are you going to utilize this? By the way, we've not completed identifying the relevant precedents because you can see here there are a few other precedents like Maru Ram versus Union of India and Vikas Chatterjee, where it's mentioned that these are cited for the fact that where power is vested in a high authority, we cannot question their application of mind. It's presumed that they've applied their mind on the relevant aspects of the matter. And then we have the answer. Now this is very clear. How do we use this for judiciary prep? After we've read the case, now did you understand? We didn't read every line. We just mark O, P, R, A. We realize is factual or not, and now it's done and dusted. Now I'm going to only write the name of this case and I'm going to see which are the relevant cases because I can use that Maru Ram case for and Vikas Chatterjee case for multiple places. When power is vested in a high authority, I can use this in multiple contexts. So my preparation now is not restricted to only mercy petition. It can be in other contexts also. So I'll keep this in mind and I'll make a flashcard where I will share that what are the purposes for which I will use this case. This flashcard, how do you print it out? You can actually prepare 2 slides of a PPT and print it out on a sheet. A4 sheet it can be, where the front and back of the sheet will have the relevant details of the case. I'll show you a sample flashcard also very shortly. Do you realize how simple it becomes to read a judgment like this? Would you like to learn how to do that? Imagine if you could do this for all your judiciary prep. You don't have to memorize everything. You just have to find the relevant parts and edit. Now I can show you a flashcard as well. I'll just hook up a PPT slide to show you that. When I create the flashcard, this is what PPT slide would look like. Vinay Sharma versus Union of India, 2020 Supreme Court, key points of law discussed on mercy petition, review of death sentence, power of judicial review of court, writ or curative petition. For both, they had some opinions on that. Conclusion: Supreme Court did not find any ground for exercise of judicial review of the order of President of India rejecting the petitioner's mercy petition and accordingly dismissed the writ petition. Propositions of law that were restated. Existing propositions of law. President can act as per grace and humanity in appropriate cases. President has wide powers to consider fresh evidence. Must take advice of Council of Ministers. President's decision can be reviewed if it is malified, arbitrary, or does not consider all relevant materials and factors. And then I have a memory technique to remember this also, but we'll get into that later. And then I create a list of leading cases that were cited. Shatrughan Chauhan and another versus Union of India, Narayan Dutt and others versus State of Punjab, and Epuru Sudhakar versus State of Andhra. Imagine doing this for every case that you read for judiciary prep, or getting it pre-prepared also. At the time of revision, all I'm going to do is that I'm just going to see this much. And in fact, if I have everything in such a concise way, I can revise multiple times. Before I go to sleep, I could just flip through 10 cases relating to the subject I'm studying. And over time, in my mind, things get cemented, because many people have a problem with how to memorize things, how to remember things. If I do this, my practice and familiarity with the materials increases. And that is the first way to remember better. The second way to remember better is to practice writing answers for the types of questions that can be asked around this question. The second way is to practice writing the types of answers around questions that can be asked on this case. Now, that's the second part. We do that separately for our students. But if you do that as well, and then you get corrections and feedback on it, then you have mastered it. I hope you found this useful. Let us know in the comments if you liked it. And do not forget to follow us.